Amending a trust and doing so correctly seems like something that should be straightforward and not leave much wiggle room for interpretation, right? You go to your attorney, have them draft an amendment to the trust, then you sign it, and you have a notary public notarize your signature. Nice and easy. However, the fact that I'm here talking about trust amendments again means that either I love the sound of my own voice, which I do, you got me, but there's not an insignificant amount of litigation surrounding the validity of trust amendments, even where the rules are relatively cut and dry. So without further ado, let's talk trust amendments again and some litigation that others went through, so hopefully you don't have to. Let's dive in. I'm attorney Andrew Bethel of Bethel Law, where we discuss estate planning, finances, real estate, and taxes. If you've been following our channel for a little while, then you've likely seen this video called When a Post-it Note Ruins Your Trust. What's relevant about that video today is the fact that in that video, we discussed the case of Pena v. Day, wherein someone tried to argue that handwritten changes made on the settlor's trust, along with a post-it note slapped onto it containing the settlor's handwritten name, constituted a valid amendment to the trust. Now in that case, the court didn't buy it, saying that if the trust itself doesn't specify the proper procedure for amending a trust, then we go to the default rules of the settlor being able to amend or modify a trust by simply executing a written statement signed by the settlor and delivered to the trustee of the trust. In Pena, we had a trust with handwritten changes not signed by the settlor and not delivered to the trustee. It was sitting in a drawer and found after the settlor's death. Well, wouldn't you know it, it's 2023 and we have some fresh California litigation that speaks on the same topic because someone found that secret trust amendment after the settlor's death. This time, it wasn't in a drawer, but it was in a closet. Diaz v. Zuniga is a case from just this year wherein the Second District Court of Appeals held that where a trust contains a provision outlining a specific procedure for amending a trust, that procedure must be followed to amend the trust. A trust amendment that didn't follow the specific procedure would frustrate the settlor's intent. Very straightforward, right? If the trust says you have to like, subscribe, and ring the bell on the video, then you better do all three. Don't just like and subscribe, but choose not to ring the bell because you subscribe to our monthly newsletter anyway. Hint, hint, link below. You have instructions in the trust. Follow what they say. Now in this case, the rule is pretty unremarkable in its simplicity, but the facts of the case give some hints at what must be some juicy family drama. So grab your coffee, got some cheese made for you. It's story time. In this case, we have a trust that explicitly states that for any amendments to the trust to be valid, the settlor was required to deliver an amendment to the trustee by certified mail. Delivery to the trustee is standard. Delivery by certified mail is a little extra, but okay. Well, the settlor died and an amendment to his trust was found in his closet, signed in an envelope addressed to his attorney, but zero indication it was delivered to the trustee via certified mail. The kicker is that the settlor himself was the trustee of the trust at the time of the amendment, meaning that while all this would have satisfied the normal requirement of delivery to the trustee, he gave himself a copy. Because the trust specified that delivery to the trustee could only be done by certified mail, the fact that the settlor here failed to deliver to himself via certified mail a copy of his own trust amendment meant that this closeted amendment was technically invalid. Now, of course, this wasn't a simple amendment that was only adding some legalese or something. No, it was an amendment that altered the distribution of the trust, and now that the court is holding this closet amendment invalid, there are some beneficiaries who are not happy and they sue, which is why the case got as far as it did and likely why we know about it today. These unhappy beneficiaries lost at every level, all because of that certified mail requirement and someone not mailing themselves a copy of their own trust amendment. Again, the court found that if the trust provides specific instructions, then you better follow them to the letter. Otherwise, the amendment isn't valid. If the trust requires the settlor to record themselves jumping up and down after signing the amendment, then once they sign, they best get jumping. As a small aside, I do just want to draw attention to the fact that the co-trustees of the settlor's trust in this case found this amendment that was otherwise typed up and signed, and their first thought was to look at the specific amendment procedures outlined in the trust and ask the court to weigh in on its validity. Now, sure, it was what they were supposed to do and ultimately the right call in that the amendment didn't conform to the terms of the trust. However, I feel like there is some background information that we're not privy to here that might shed some light on why this was the train of thought in the first place. It could be spicy family drama, or I could easily see it being that the settlor had some sort of fill-in-the-blank, off-the-shelf, one-size-fits-all trust to where there may have been a lot more red flags we're unaware of. Although to counter that thought, we have the fact that the settlor apparently had an attorney, and the certified mail requirement, while not necessarily standard practice, it wouldn't raise too many eyebrows if we had a third party as a trustee, which notably was not the case here. Additionally, where we have trusts and probate litigation, we're typically trying to determine what was the intent of the settlor here so we can best carry out their wishes after they're no longer here to provide clarity or context. And these rules on how to amend the trust are mainly here to protect the settlor's intent and wishes from being overridden by dodgy legal documents or advice. In this Diaz case, I am sympathetic to the case of the angry beneficiaries because, from their perspective, the settlor's intent is being frustrated or inhibited from being carried out due to a very simple and perhaps silly process requirement. Yes, the settlor failed to follow instructions down to the letter, but it seems like they wanted these other beneficiaries to get something. Otherwise, they wouldn't have gone through the process of doing the trust amendment, but because they didn't mail themselves their own trust, their wishes aren't going to be carried out. Again, I think there's a lot more context here we're missing. That might help at least explain the situation. However, I am sympathetic to the feeling of the settlor's wishes are being ignored due to a technicality, but it is what it is. Let's bring this back to you and your trust. If you do have a trust and you want to make a change to that trust, or even revoke it for that matter, then you first need to find the provision in the trust that discusses the power to amend or revoke that trust by the settlor or trustor. In all likelihood, the trust will have some language there setting forth the procedure to amend or revoke the trust. It will likely be straightforward and require a signed writing by the settlor delivered to the trustee. That's the default rule, and it's not too often I see outside trusts that deviate from it. If you don't see that language, then I would first recommend speaking to an attorney to be sure. Otherwise, you're in the default rules of the California Probate Code, sections 15401 and 2, which is, in essence, a signed written statement from the settlor delivered to the trustee. All right, kept you long enough. Remember, it's your future, your family, and your legacy. Now's not the time to get lazy and cut corners. If the trust says jump, you better look for some guidance in that trust on how high. I'm attorney Andrew Bethel. If you have something you want me to cover or a question, then feel free to drop a comment below. Don't forget to like and subscribe if you found this video interesting, and check out our other great videos. Stay informed, and I'll see you next time.